The Supreme Court chamber glowed under its signature formal lighting, bronze sconces casting a warm yet austere glow across the marble columns and mahogany benches. Hundreds of spectators, civil rights leaders, journalists, law students, and ordinary citizens sat in rapt silence, the air thick with anticipation. At the center of the raised bench sat Chief Justice John Roberts, his black robe impeccably pressed, his silver hair neatly combed, his expression a mask of judicial calm that barely concealed the authority of 18 years leading America's highest court. To his left and right, the 8 associate justices formed a semicircle of power. Kagan, Thomas, Alito, Sotomayor, Kavanaugh, Barrett, Gorsuch, and Jackson, each a legal titan in their own right. The camera, positioned discreetly in the corner for the rare public broadcast, slowly panned across the gallery. Whispers fluttered like trapped birds. A court officer raised a hand for silence. Then, the clerk's voice rang out, clear and resonant. The Honorable Court now recognizes Congresswoman Jasmine Felicia Crockett of Texas's 30th Congressional District, appearing as amicus curiae, friend of the court. Roberts gave a curt nod, the faintest tightening at the corners of his mouth. Representative Crockett, he said, his voice smooth but weighted with institutional gravitas. You have 10 minutes. The clock begins now. Jasmine Crockett rose from the council table and walked forward with deliberate, unhurried steps. At 42, the freshman congresswoman from Dallas cut a striking figure. Tall, poised, her bold crimson suit a defiant splash of color against the chamber's muted tones. Her hair was pulled into a sleek low bun, diamond studs glinting under the lights. She had been a public defender, a civil rights litigator, a state representative, now in her first term in Congress. She was already a national voice on voting rights, racial justice, and constitutional fidelity. And today, she was here to confront the very institution that had, in her view, enabled a decade of democratic erosion. She placed her leather binder on the podium, adjusted the microphone, and looked up, locking eyes with each justice in turn. Thank you. Mr. Chief Justice, and may it please the court, she began, her voice deep, steady, and unmistakably Texan. I appear before you today not merely as a member of Congress, but as a former prosecutor who has stood in courtrooms across this state and watched the machinery of suppression dismantle the most sacred right of citizenship, the right to vote. A pause. A breath. The room leaned in. This case, Williams v. Texas Election Commission, is not about administrative convenience. It is not about election integrity in the abstract. It is about whether the Constitution still means what it says when it declares that no state shall deny or abridge the right to vote on account of race, color, or previous condition of servitude. Roberts shifted imperceptibly in his high-backed chair. His fingers rested lightly on the bench, but his eyes narrowed, just a fraction. This was supposed to be a sleeper case, a challenge to Texas's strict voter ID law, SB 17, passed in 2021 after the Shelby County decision gutted federal preclearance. The court had granted certiorari expecting a narrow technical debate over Crawford versus Marion County and Brnovich. They had not expected her. Crockett gestured toward the large display screen behind her, where her team had prepared a series of data visualizations. Let us begin with the facts on the ground, she said. In Texas, 23.4% of black citizens and 27.1% of Latino citizens do not possess the 6 forms of photo ID required under SB 17. For white citizens, only 4.7%. That is not a statistical anomaly. That is a pattern. She clicked to the next slide, a heat map of Texas counties. In the 50 counties with the highest proportion of black and Latino residents, 68% of Department of Public Safety offices, the only places to obtain a compliant election identification certificate, have reduced operating hours since 2021. Wait times now average 4.2 hours. In the 50 whitest counties, hours have increased by 12%, and wait times average 41 minutes. Gasps rippled through the gallery. A journalist in the front row typed furiously. CNN's Kyron flashed. Crockett drops data bomb on SCOTUS. Roberts leaned forward, his microphone catching the faint click of his pen. Congresswoman, he interjected, his tone clipped but controlled. The court is familiar with general demographic trends. Please direct your remarks to the specific constitutional standard at issue, whether SB 17 imposes an undue burden under the Anderson-Burdick framework or triggers strict scrutiny under the 14th or 15th Amendments. Crockett did not flinch with respect. "Mr. Chief Justice," she replied, her voice rising just enough to command the room. "The Anderson-Burdick balancing test cannot be applied in a vacuum. The burden is not moderate when 87-year-old Korean War veterans are turned away at the polls because their birth certificates, issued in segregated hospitals, do not match their Social Security cards by a single initial." She signaled to her aide, a young black woman in a navy suit, who distributed thick binders to the justice's clerks. "Before you, Your Honors, are 72 sworn affidavits from Texas. Voters denied their constitutional right to vote in 2022 and 2024. I will highlight 3. She held up the first document. Mary Louise Wilson, age 84, born at home in Lufkin, Texas, 1939. No birth certificate issued, standard practice for black babies under Jim Crow. Her baptismal record from Mount Corinth Baptist Church lists her middle name as Louise. Her Social Security card, issued in 1965, lists L. She has voted in every election since LBJ. In November 2022, she was provisionally ballot rejected. Her vote was never counted. Next affidavit. James Anthony Fuentes, 61, Army veteran, 100% disabled, wheelchair user. Lives in rural Zavala County. The nearest DPS office is 52 miles away, not ADA compliant. He was told to come back when you can walk. He cannot. He has not voted since 2020. Third, Marisol Ramirez, 19, first-time voter, UT Austin sophomore. Her tribal ID from the Alabama Coshada tribe was rejected. The poll worker accepted a concealed carry license from the white student behind her. Ms. Ramirez's provisional ballot was discarded. The chamber was silent. Even the justices, who had seen every manner of human drama, appeared transfixed. Justice Ketanji Brown Jackson leaned forward, her legal pad filling with notes. Justice Sonia Sotomayor's eyes glistened. Justice Clarence Thomas stared straight ahead, unreadable. Roberts cleared his throat. "Congresswoman, while these anecdotes are compelling, they do not, standing alone, establish a statewide constitutional violation. We require systemic evidence, not emotional appeals." The word emotional landed like a slap. Crockett's eyes flashed, but her voice remained steel calm. "Mr. Chief Justice, with all due respect, the Constitution is not a theoretical exercise. It was written in the blood of enslaved people, ratified in the aftermath of a civil war, and amended by the sacrifices of John Lewis on the Edmund Pettus Bridge. When 278,000 eligible Texans, 42,000 in my district alone, are prevented from voting, and when those Texans are disproportionately black and Latino, that is not emotional, that is evidence." She clicked to a new slide. A line graph titled, "Voter Disenfranchisement by Race, Texas 2021-2024. Black voters are disenfranchised at 4.8 times the rate of white voters, Latinos at 5.2 times. That is not neutral. That is not incidental. That is the very definition of discriminatory effect under Arlington Heights, and it demands strict scrutiny." Roberts's jaw tightened. He had authored Shelby County. He had written the majority in Brnovich. And now, a first-term congresswoman was dismantling his legacy. Point by point in front of the nation. "Congresswoman," he said, voice now edged with frost, "you will address the legal framework, not policy critiques. This court does not sit to remedy every perceived inequity." Crockett smiled, small, sharp, fearless. "Your Honor, the 15th Amendment is the legal framework, and it does not say the right to vote shall not be denied, unless the burden is merely severe, not impossible. It says shall not be denied." "Full stop!" The gallery erupted in murmurs. Roberts banged his gavel, once, twice. "Order. Congresswoman, you will cease questioning the court and adhere to proper advocacy." But Crockett was ready. She reached into her binder and withdrew a slim, leather-bound volume, a pocket constitution. She held it aloft like a torch. "Mr. Chief Justice, before you silence a duly elected representative of 750,000 Americans, let us both consult the document that binds us both." She opened it to a bookmarked page. Article 1, Section 2. The House of Representatives shall be composed of members chosen every second year by the people. The 14th Amendment. No state shall deny to any person within its jurisdiction the equal protection of the laws. The 15th. The right of citizens To vote shall not be denied or abridged on account of race. She stepped closer to the bench, within the bounds of decorum, but close enough that Roberts could see the fire in her eyes. When you threaten to cut short my time for speaking truth about constitutional violations, you are not enforcing procedure. You are enacting the very crisis I came to warn against. One branch of government silencing another in the name of control. Dead silence. Even the cameras seemed to hold their breath. Justice Elena Kagan's eyebrows rose. Justice Amy Coney Barrett scribbled furiously. Justice Neil Gorsuch looked down at his hands. Roberts's face flushed. A rare crack in the judicial facade. Congresswoman Crockett, he said, voice low and dangerous. This is your final warning. Conclude your argument, or I will terminate your presentation. Crockett did not yield. I will conclude. Your Honor, with the plain text of the law you swore to uphold. She turned to face the full bench, her voice ringing clear. SB 17 closes ID issuing offices in 84% of majority-minority neighborhoods. It accepts NRA memberships as proof of identity but rejects tribal IDs. It imposes a $50 fee for underlying documents, effectively a poll tax. And it does so in a state with a documented history of racial discrimination in voting. If this court upholds that law, it will not be interpreting the Constitution. It will be rewriting it to say, equal protection for some. She paused, letting the words settle. Voting is preservative of all other rights. If this court allows states to erect barriers that silence hundreds of thousands of voices, voices that look like mine, like Ms. Wilson's, like Mr. Fuentes's, then the promise of the 15th Amendment is dead, and the soul of our democracy dies with it. Roberts's gavel hovered. Congresswoman Crockett, she cut him off, not with volume, but with unshakable conviction. Mr. Chief Justice, the Constitution does not expire when the clock runs out, and neither does the truth. She closed the document with a soft thud. I yield back the balance of my time. To the people. The chamber exploded. Reporters scrambled. Phones buzzed. Within minutes, the clip was viral. Dr. Crockett vs. Roberts trended nationwide. Pundits called it the speech that shook the Marble Palace. Legal scholars debated whether a member of Congress could be held in contempt for constitutional truth-telling. Roberts adjourned the session early. But the confrontation was far from over.